Okay, so good morning. Let's proceed to Chapter 7, Extinguishment of Sale. So, Chapter 7, Extinguishment of Sale starts with Article 1600 saying that sales are extinguished by the same causes as all other obligations, by those stated in the preceding articles of this title, and by conventional or legal redemption. So, I am aware, and you have already told me that you already finished or you have already completed your course with obligations and contracts. So, you must have an idea of what are the causes of extinguishment of obligations and contracts. So, if we can recall shortly or briefly, okay, obligations are extinguished. Obligations are extinguished first by payment or performance. Of course, if your obligation consists of a monetary obligation, if you pay them with the proper amount in time, then the obligation is considered as extinguished. If your obligation consists of performance, let's say for example delivery, okay, your obligation to deliver is extinguished by the moment you deliver. That's the said property. The second one is by the loss of the thing due. If what you are, let's say for example, you are to deliver a specific thing. If it's a specific thing na isa lang yan, bagay na yan sa buong mundo, let's say for example, your car with the plate number like this and like that, if yan is nasunog or nasira to the point na unfit na siya, hindi na pwede magamit, this loss and your obligation is deemed extinguished. Pero kung yung thing na nawala is a generic thing, meaning it can be replaced, okay, then hindi ma-extinguish yung obligation. Okay? So you have to decipher whether the thing is a specific thing or a generic thing. Okay? Third, by the condonation or remission of the debt. Okay? When we say condonation, ibig sabihin mo, bait sa creditor mo kasi kinakondone niya na yung debt mo. Huwag mo nang bayaran. Sige, huwag mo nang bayaran. Okay, yung mga ganun ba? O yung sa pamilya nyo, sa relatives nyo, or even sa kaibigan, di ba? Huwag mo nang bayaran, okay na. The obligation is deemed extinguished. Yan. Kaya mahirap ang magpautang sa kaibigan or sa kapamilya. Why? Why? Because if nagpautang ka sa relative, consider it as a donation. Okay. Kasi mahirap nang singilin yan. Kasi pag siningil mo, ikaw pa ang masama. Ikaw pa ang diskumpiyado, ba't ka naniningil na ganito, ganyan, di ba? Well, ganun talaga. Fourth, by the confusion or merger of the rights of creditor and debtor, meaning when the creditor becomes the debtor, okay, or the debtor becomes the creditor in their rights. So, kung wari, may utang, say for example, 10 years ago, or 5 years ago, nagpautang ka kay A, okay? And this year, nangutang ka kay A, okay, you can merge your rights para ma-determine kung sino pa ang mayroong balance. Diba? Parang ganun lang. 5, compensation. Okay, same principle, you compensate the debts and the credits of both the debtor or the creditor, but in this case we apply it for the buyer and the seller, the vendor and the vendee. Innovation is change in the contract. When there's a substantial change in the contract that does not merely amend the contract but to create a new one. So yan yung novation. Babaguhin mo yung contract. Yun yung other causes of extinguishment of sales. And also conventional or legal redemption, which is what is provided under the law on sales. So itong 1, 2, 6, na-discuss nyo na to sa obligation and contracts nyo. Actually, no need to elaborate this one because you know this one. Okay? We'll focus on conventional redemption and legal redemption. First, conventional redemption with Article 1601. What is a conventional redemption? Conventional redemption shall take place when the vendor reserves the right to repurchase the thing. So, the vendor daw, the seller, reserves the right to repurchase the thing sold. Yung binenta niya, bibilhin niya daw ulit. Ayan yung conventional redeem. Kumbaga, i-redeem niya ulit yung property. With the obligation to comply with the provisions of Article 1616. Okay? Meaning, Article 1616 states that when you redeem, of course, you are going to repay. Diba? Bayaran mo ulit. Hindi yung balikan. Bayaran mo ulit. Bibili mo ulit. Okay, with all the expenses. We'll discuss Article 1616 later. And other stipulations which may have been agreed upon. So, Article 1601 talks about a pacto de retro sale. Ang tawag sa contract of sale with the right to repurchase is pacto de retro sale o yung iba compacto de retro sale. Okay, meaning the seller will sell the property to the buyer, but the seller also reserves the right to repurchase that same property from the buyer. Meaning, paano? Let's say for example, I sold to you my motor vehicle kasi pupunta na ako ng Amerika. Okay. After 6 months, I will reserve my right to repurchase that motor vehicle kasi babalik na ako dito sa Philippines. Okay, so within 6 months, okay, may right si seller na bilhin ulit yung property pertaining to that pacto de retro agreement. So, pwede niyang i-redeem yun within 6 months. If nag-lapse yun, hindi na niya pwedeng i-redeem yun and the buyer can now consolidate his ownership in favor of him. Okay? Itong right to repurchase or right to redeem is only an accidental element. Why? Because hindi siya natural element, meaning hindi mo siya ordinarily makikita sa contract of sale. Okay? Itong right to redeem, makikita lang yan kapag especially provided for in the contract and if that is the tenor of the agreement of both the seller and the buyer. Okay? Inadequacy of price cannot be considered a ground for rescinding a contract. So if it's a pacto de retro sale and the price is inadequate, meaning masyadong mababa yung price for the value of that thing. Let's say for example, the vehicle is valued at 700,000 but the vehicle is sold at 300,000. So masyadong mababa. There's an inadequacy of price. Hindi pwedeng gamitin ang rescission. Why? Because ultimately, pacto de retro sale siya. Ultimately, bibilhin niya din ulit. Okay? Hindi naman siya normal sale. Diba? If matandaan nyo before, in a normal sale, if there is an inadequacy of price, pwede siyang ground for rescission. But in this case, hindi pwede. Why? Because hindi siya normal na absolute sale. Instead, it is a pacto de retro sale. Okay? Article 1602. The contract shall be presumed to be an equitable mortgage in any of the following. Wait lang, nag-brown out na eh. Okay? So, in these instances, yung contract daw is magiging equitable mortgage. What is an equitable mortgage? Equitable mortgage looks like a sale, a contract of sale. So, pag titignan mo siya, wala doon nakalagay na mortgage, wala nakalagay doon equitable mortgage. Ang makikita mo doon, contract of sale. Okay? But, the intention of the parties is really a mortgage. Okay? Kunwari, let's say for example, A and B. Si B kailangan niya ng pera. Okay? So, ang ginawa niya, binenta niya yung property niya. Let's say for example, a piece of land. Binenta niya yung piece of land kay A. Okay? But their agreement was that kapag nabayaran ko yung utang ko, kukunin ko yung property. So, it's not really a sale. So, their agreement is not really a sale. Pero ang ginawa nilang contract, ang in-execute nilang contract is a sale. But their intent is a mortgage. Meaning, ginamit yung lupa, which is the subject of the sale, as security for a debt. So, yung parang imbes na utang, sale na lang, tas with the right to repurchase. Parang gano'n. So, what is the remedy of the seller in that case? Ang remedy ng seller is reformation. Reformation meaning the seller will ask for the reformation of the contract. Meaning, ibabaguhin yung contract of sale. I-reveal yung true intention of the parties, which is really a mortgage. Okay? So, under Article 1602, ito daw yung cases na equitable mortgage siya, hindi siya contract of sale. Okay? Number 1, when the price of a sale with the right to repurchase is usually inadequate. Okay? Meaning, there is a contract of sale and it is not an ordinary contract of sale. It's a pacto diretto sale. Why? Because it has a right to repurchase and at the same time, it is inadequate. So, the presumption under the law, the presumption is it is an equitable mortgage. Hindi siya contract of sale. Okay? Second one, when the vendor remains in possession as lessee or otherwise. Let's say, for example, you sold A sold his house and lot to B. Okay? Normally, if you sell your house and lot, B would take possession and would take ownership of that land, okay, or in that house. But then again, what happens here is that the vendor instead remains in possession as lessee. Okay? That could be an equitable mortgage. Under the law, it is presumed that that is an equitable mortgage. Okay? Number 3, when upon or after the expiration of the right to repurchase, another instrument extending the period of redemption or granting a new period is executed. Why? Because parang hindi naman siya sale talaga eh. Why? Because, let's say for example, the original period of the right to repurchase is 6 months. Si seller, pwede niyang bilhin ulit yun within 6 months. Okay? Nag-lapse yung 6 months, hindi pa nabibili ni seller. Nag-execute ulit sila ng contract na granting a new right to repurchase. 1 year. Nag-lapse yung 1 year, nag-execute ulit sila. So parang hindi na siya sale talaga. Parang nangutang na lang talaga siya. Okay, gets nyo? So that is an equitable mortgage. Okay, hindi siya contract of sale. Okay? Number 4, when the purchaser retains for himself a part of the purchase price. Yes. Diba? Why? Because if it's really a contract of sale, when the seller delivers the property to the buyer or the purchaser must pay the full price. Okay? If he retains a significant amount of the purchase price, then maybe there's something wrong with the intent of the parties. Baka hindi naman contract of sale talaga ang intention nila. Baka mortgage. Bibigyan ng pera, ay papautangin ng pera, tapos ibibigay yung property as a collateral. Hindi siya talaga contract of sale. So, kung ganyan ang nangyari, that could be an equitable mortgage. when the vendor binds himself to pay the taxes on the things sold. Okay? So, usually, okay, it is the buyer who now owns the property. Let's say, for example, it's a real property or an immovable property. Of course, meron niyang real estate taxes. Okay? And ang magbabayad ng real estate taxes upon registration of the contract of sale and upon the transfer of the ownership and updating in the municipality or the province. Okay? Ang magbabayad na niyan, si buyer. Okay? But if after the sale and the registration or the recording in the register of property, si vendor, si seller pa rin yung nagbabayad, then that could mean one thing, na baka iba talaga yung intention nila. Baka it's not a sale. Baka it really is an equitable mortgage. Kasi dapat si buyer na ang magbabayad ng taxes, hindi na si seller. Okay? Kung si seller pa rin, ibig sabihin, siya pa rin yung may-ari. Diba? So that is Article 1602. Okay? In any other case where it may be fairly inferred that the real intention of the parties is that the transaction shall secure the payment of a debt or the performance of any other obligation. Or, just like what I said kanina, if hindi siya pumasok dito sa 5 cases, i-apply mo itong 6, which is a catch-all provision, meaning as long as the intent of the parties is a mortgage or pautang, and at the same time nagbigay ng property as a collateral to secure the payment, that is an equitable mortgage and not a contract of sale pacto de retro. Okay? And in any of the foregoing cases, any money, fruits, or other benefit to be received by the vendee as rent or otherwise shall be considered as interest, which shall be subject to the usury laws. So any money, fruits, or other benefits received by the vendee shall be considered as interest. 1603, in case of doubt, a contract purporting to be a sale with the right to repurchase shall be construed as an equitable mortgage. Meaning, if the sale is a pacto de retro sale, hindi mo siya ipapresume as sale. Ang presumption dyan is equitable mortgage. Okay? Yun yung sabi ni Article 1603. Basta pacto de retro sale siya, ang presumption mo dyan, equitable mortgage. What do you mean? If ang ibig sabihin niyan, baka ang intent is mortgage. But, you can prove that in court that the real intent is a sale. So, the court can issue a decree or a judgment whether the sale is indeed a contract of sale or an equitable mortgage. Okay, but without that judgment or without that decree, okay, that contract will remain to be as initiated by law an equitable mortgage. Okay? Article 1604, the provisions of Article 1602 shall also apply to a contract purporting to be an absolute sale. So what is Article 1602 again? Okay? Yung hindi lang pacto de retro sale ang pwedeng i-considered as equitable mortgage. Even a deed of absolute sale, as long as the intent, okay, as long as the intent shows na mortgage siya, that could be an equitable mortgage. Hindi lang basta pacto de retro sale. Okay? Article 1605, in cases referred to in Article 1602 and 04, the apparent vendor may ask, this is now the remedy of the seller. Okay, the seller may ask for the reformation of Okay? Sa cases na you don't take it? Yes, stay upstairs. Okay? In cases daw na merong equitable mortgage, okay, the remedy for the seller is reformation. Meaning, you are to reform the contract to reveal the true intention of the parties. Okay? Hindi siya rescission, cancellation, but reformation. Okay? Ibig sabihin, the contract, the essential elements of the contract will stand, but it will stand according to the true intention of the parties. Kung ano ba talaga? Contract of sale ba talaga or equitable mortgage? So it will be determined by the court. So if it is determined by the court, then the proper provisions of the law will apply. Kung contract of sale siya or equitable mortgage. So, the right referred to in Article 1601 okay? Under Article 1606, in the absence, the right referred to in Article 1601, meaning the right to repurchase. Okay? The right to redeem, the right to repurchase by the seller in a pacto de retro sale, in the absence of an express agreement, meaning there is an agreement with regards to the right to repurchase, the right to redeem, but there is no agreement until when. Okay? Say for example, the seller has a right to repurchase pero walang sinabi na period. Within 6 months, okay, from the sale, walang nakalagay. Okay, kapag wala daw nakalagay, the right to redeem or the right to repurchase shall last 4 years from the date of the contract. So kung walang agreement as to the term, kung kailan i-exercise yung right to redeem or right to repurchase, 4 years. Should there be an agreement, ibig sabihin, merong term, ba 6 months, 30 days, merong term na exercise yung right to repurchase, the period cannot exceed 10 years. So if it's stated there that the period shall be 15 years, no, the period to redeem shall only last for 10 years. Okay, as clear as day, okay? However, the vendor may still exercise the right to repurchase within 30 days from the time final judgment was rendered in the civil action on the basis that the contract was a true sale with right to repurchase. Meaning, di ba na-mention natin kanina, the remedy of the vendor is reformation. Okay? If it is declared that that contract is not an equitable mortgage, but rather it is a true sale with the right to repurchase, you still have 30 days, okay, from the final judgment in that reformation case to redeem or to exercise the property. So, if let's say, for example, the vendor asked for reformation, okay, and a decision came out that the sale was indeed a contract of sale with the right to repurchase and not an equitable mortgage, okay, the seller still has 30 days from final judgment thereof to redeem the property. This is aside from the agreement stated kung 10 years or kung walang agreement 4 years. So, Yun yung period to redeem or prescription of redemption period. Okay? Article 1607, in case of real property, the consolidation of ownership in the vendee by virtue of the failure of the vendor to comply with the provisions of Article 1616 shall not be recorded in the registry of property without a judicial order after the vendor has been duly heard. Meaning, let's say for example, there's a pacto de retro sale, okay, a sale with the right to repurchase. Okay? And sabi doon, the seller can repurchase the property within 6 months from the date of the contract. Okay? Let's say, for example, after 7 months or after 1 year, the seller hasn't redeemed the property. What now can the buyer do para lumipat sa kanya yung property? The buyer, okay, must file for a consolidation of ownership. Okay, consolidation of ownership. Take note, this only involves real property, bahay, lupa. Okay? So, he must now file a case for consolidation of ownership. Ang mangyayari dyan, bibigyan ng time si vendor na mag-answer. Ang sabi dyan, after the vendor has been duly heard. So, after na sumagot si vendor, okay, may decision na court. Kung sabi ni court for consolidation of ownership of real property, then sa kanya i-record yan sa registry of property. Okay, sabi dyan, consolidation of ownership shall not be recorded in the registry of property without a judicial order. So, pag nag-lapse yung period to redeem, the buyer now must then file a case for consolidation of ownership of that real property before he registers that to the registry of property. Okay? That's Article 1607. Article 1608, the vendor may bring his action against every possessor whose right is derived from the vendee. Meaning, dyan pa lang muna tayo sa una. Let's say for example, the vendor sold a piece of land to B. Okay. A sold a piece of land to B, pacto de retro. Okay? Ang agreement nila is he can redeem that within 10 years. So, gamitin natin yung 10 years. Okay? On the third year, B resold the property to C. On the fifth year, C resold the property to D. Okay? Basta within 10 years, okay, pwedeng i-redeem yan ni vendor. Kahit pa hindi na kay original buyer. Basta na-derive nila yung ownership or yung right nila kay buyer, pwede niyang i-redeem yan as long as within the 10 years. Okay? Yun yung sinasabi ni 1608. Even if in the second contract, take note of this, even if in the second contract no mention should have been made of the right to repurchase without prejudice to the provisions of the mortgage law and the land registration law with respect to third persons. Meaning, dun sa contract ni A kay B with right to repurchase, nandun yung right within 10 years. Tapos yung contract ni B kay C, walang nakamention na right to repurchase ni A. Kay C kay D, walang nakamention. Okay? Basta within 10 years, pwedeng i-exercise yun ni A. Pwede niyang bilhin ulit. Okay? Even without mentioning his right to repurchase in the subsequent contracts. Okay? So, we can now understand that this right to redeem or right to repurchase is a real right. Diba? This is a real right. Okay? By the vendor. 1609, the vendee is subrogated to the vendor's rights and actions, of course. Okay? In a pacto de retro sale, A sold the piece of land to B, pacto de retro. Okay? Of course, B now is subrogated to the vendor's rights, meaning B now is considered as the owner. Yun naman yung pacto de retro sale. Si B yung owner na Pero meron lang period of time na pwedeng bilhin ulit ni A. Ganun lang naman yun. Okay? So, meaning of subrogated, the vendee will now become the owner. He has now the right to mortgage that property. He has now the right to occupy that. Lahat ng rights niya, pwede niyang gawin. He can lease that kasi sa kanya na yan. Okay? Just like a normal buyer. Ang difference lang is merong right si vendor na mag-repurchase. Article 1610, the creditors of the vendor cannot make use of the right of redemption against the vendee until after they have exhausted the property of the vendor. Okay? This one naman, with regards to exhaustion of remedies. Okay? Meaning, yung creditors ni vendor, okay, of course, let's say for example, si A and B, A being the vendor, A sold this property to B, pacto de retro. Okay? Ngayon, biglang naghabol yung creditors ni A, sabi nila wala na siyang pera. Okay? Dapat mo nang ma-exhaust lahat ng other properties ni A, meaning lahat muna yun ma-attach. Okay? Ma-attach nila sa court before sila mag-go after dun sa binenta through pacto de retro na property. Why? Because if it's a pacto de retro sale, it's a valid pacto de retro sale, the vendee is subrogated to the rights of the vendor. Si vendee lang may-ari. Saka lang pwedeng habulin ni creditor yung property ni vendor if wala nang natira sa ari-arian ni vendor. Doon lang nila pwedeng habulin yung property niya. Article 1611, in a sale with the right to repurchase, the vendee of a part of an undivided immovable, okay, so the buyer of a part of an undivided immovable who acquires the whole thereof may compel the vendor to redeem the whole property if the latter wishes to make use of the right of redemption. Okay, meaning that if it's a sale, pacto de retro, okay, and the vendee, okay, acquired the part of that undivided immovable, let's say for example, a piece of land, okay, na-acquire niya yung, let's say for example, 100% yung buong lupa, na-acquire niya yung 50%, he may compel the vendor to redeem the whole property if the vendor wishes to make use of the right of redemption. This is only proper kasi nga, the subject thing is undivided and it is an immovable. Okay, hindi mo siya mahati. Okay, hindi mo naman pwedeng kalkalin yung lupa at yun ang iuwi mo, hindi naman pwedeng gano'n. Okay, so you are to redeem the whole property, the whole real property. In 1612, if several persons jointly and in the same contract should sell an undivided immovable with the right of repurchase, meaning several persons jointly sold an undivided immovable with right of repurchase, none of them may exercise this right for more than his respective shares. Let's say for example, A, B, and C sold the piece of land they owned to Mr. D. Okay? A can only redeem his share. B can only redeem his share. C can only redeem his share. Okay? A cannot redeem the whole property. Okay? None of them may exercise this right for more than his respective share. So kung i-redeem nila yung buong property, dapat silang tatlo. Okay? The same rule shall apply if the person who sold an immovable alone has left several heirs. In which case, each of the latter may only redeem the part which he may have acquired. So, dito naman, let's say for example, a pacto de retro sale between A and B. Okay? Term niya, 10 years. Okay, ngayon patay na si A na nagbenta kay B, pero meron siyang heirs. Ang heirs niya si XYZ. Okay? Itong si XYZ, X cannot redeem the whole property. Okay? He can only redeem the property with respect to his share as an heir. Okay? As a tagapagmana, as an heir. Yun lang ang pwede niyang i-redeem. Hindi niya pwedeng i-redeem yung buo. Kung gusto nilang i-redeem yung buo, all of them or XYZ should redeem the whole property. Why? Because just like as stated in the first paragraph, none of them may exercise the right for more than his respective share. Kumbaga, to each his own. To each share is his own share. Kumbaga ganun. Okay? That's Article 1612. Article 1613, in the case of the preceding article, meaning 1612, the vendee may demand of all the vendors or co-heirs that they come to an agreement upon the purchase of the whole thing sold. And should they fail to do so, the vendee cannot be compelled to consent to a partial redemption. Meaning, on the part of the vendee, referring to the same case as Article 1612 na madami ang nagbenta. Siyempre, kapag i-redeem nila, portion lang nila, hindi yung buo. Ngayon, pwedeng i-demand daw ni vendee na lahat, let's say for example, ABC sold pacto de retro property to B. Okay? B may demand that XYZ come to an agreement to purchase the whole thing back. Diba? Para bilhin nila ulit yung property. Okay? Pwede niyang i-demand yun. Pero, hindi nila pwedeng pilitin si B. Hindi nila pwedeng pilitin si D, the buyer, na pumayag siya for partial redemption. Pwede siyang pumayag, pero hindi siya pwedeng mapilit. Sabi dito, should they fail to do so, the vendee cannot be compelled. Hindi mo pwedeng pilitin to consent to a partial redemption. There can be a partial redemption if the vendee consents or agrees. Okay? But if the vendee does not like partial redemption, kung gusto niya whole redemption, you cannot compel the vendee na pumayag for that. Okay? That is Article 1613. It talks about, in relation to Article 1612, it talks about partial redemption and redemption as a whole. Okay? Article 1614. Each one of the co-owners of an undivided immovable who may have sold his shares separately may independently exercise the right of repurchase as regards his own share, and the vendee cannot compel him to redeem the whole property. Ito naman, iba naman ito. Let's say for example, ABC, inherited a piece of land from their ancestor. Huwag mo natin pangalanan. Basta ABC. Okay, so they owned the portion of land. So sila, ang tawag mo sa kanila na herederos, na heirs, is co-owners. Sila yung may-ari ng property. Co-owners sila ng immovable. Hindi nila paghahatian kasi nga, immovable yan in undivided. Hindi pwedeng mahati. Okay? Kaya co-owners. Kaya madami kayong makikita or maririnig na may mga lupa na silang magkakapatid ang may-ari or magkakapamilya ang may-ari. Sila yung co-owners. Ngayon, kung isa doon, let's say for example, si C sold his shares separately, okay, to a buyer of his own choice. Okay? Pwede, each one of the co-owners may independently exercise the right of repurchase as regards his own share. Kasi ang nabenta lang naman ni C, dun sa property, let's say for example, dun sa lupa, na silang tatlo ni ABC ang may-ari, yung share niya lang ang nabenta niya. Yung share niya lang nabenta niya. Hindi niya naman pwedeng ibenta yung share ni A tsaka ni B. Yung share niya lang. And the vendee cannot compel him to redeem the whole property. Okay? So, pag separately sold, they can redeem their own share. Hindi yung they redeem the other property share kasi hindi naman yun yung binenta nila. Okay? 1615. if the vendee should leave several heirs. Ito naman, kanina yung vendor yung nag-leave ng heirs, di ba? Namatay siya, yung mga heirs niya yung nag-redeem or nag-repurchase ng property. Ito naman, if the vendee should leave several heirs, the action for redemption cannot be brought against each of them except for his own share, whether the thing be undivided or it has been partitioned among them. So, kung patay na yung vendee at heirs na lang ang natitira, okay, i-recover mo to each of the heirs. Hindi yung i-recover mo sa isa lang. Kasi meron na silang share dyan. Whether it has been divided or partitioned or whether it remains intact. Okay? Ang recovery mo is to these several heirs. Okay, but if the inheritance has been divided and the thing sold has been awarded to one of the heirs, the action for redemption may be instituted against him for the whole. Okay, meaning, beyond being partition, okay, let's say for example, lupa na partition, okay, hindi lang na partition, kundi nakapaglabas na rin ng title yung isang heir, pwede mo sa kanya i-claim yung buong property. Okay? So, yun yung ibig sabihin ng Article 16.15. Yung una, whether it has been intact or it remained intact or partition. Yung pangalawa, when it has been awarded to one of the heirs. The difference is, yung sa una, you must redeem the property as the seller to each heir. Okay? Kasi nga, they have their own shares. Ito naman sa pangalawa, kapag may partition na and nakapaglabas na ng title, then you can recover to that heir na nakapaglabas ng property or ng title. The vendor cannot avail himself of the right of repurchase. Ito na yung Article 16.16 na sinasabi natin kanina. The vendor cannot avail himself of the right of repurchase without returning to the vendee the price of the sale. Di ba nga, repurchase? So if you are going to exercise your right to redeem or right to repurchase, of course, you are going to buy back the property. So you return the price of the sale in addition to what? The expenses of the contract and any other payments made by reason of the sale and the necessary and useful expenses made on the thing. Diba? If nung binenta mo siya, medyo hindi maganda yung lupa, pero nung bibilhin mo na siya ulit is naayos na, napaganda na yung lupa, all the necessary and useful expenses, babayaran mo din kay buyer. Kasi nga, bibilhin mo na yung lupa. Kumbaga, nag-improve yung lupa from its original state, nung binenta mo, nung bibilhin mo na ulit, ang ganda na, ang laya na, you have to pay that also. Hindi lang yung price. Okay? Article 16.17, if at the time of the execution of the sale, wait lang. If at the time of the execution of the sale, there should be on the land. So, at the time na binenta mo yung lupa, mayroon daw visible or growing fruits. So, makikita mo na may visible or growing fruits. There shall be no reimbursement for or prorating of those existing at the time of redemption if no indemnity was paid by the purchaser when the sale was executed. Meaning, let's say for example, A sold piece of land to B, pacto de retro. At the time of the sale, meron ng visible or growing fruits. Pero hindi yun kasama dun sa price ng sale. Pero wala yung additional price dun sa price ng sale. Meaning, kasama na siya dun sa land. walang reimbursement dun. Why? Because it's presumed na included na siya dun sa price ng land. Pero kung meron, kung let's say for example, may presyo yung lupa and meron ding presyo yung visible or growing fruits, dun ka na mag-account at the time na i-redeem mo. Okay? Pero kung wala naman, binenta yung lupa sa'yo na merong mga fruits na doon, merong visible or growing fruits, at wala naman nagbago siya sa presyo, therefore, kapag i-redeem mo, walang additional expenses or reimbursement. Okay? Should there have been no fruits at the time of the sale? So, at the time of the sale of the land, wala daw fruits. Pero nung niredeem mo na, meron ng mga fruits. They shall be prorated between the redemptioner and the vendee, giving the latter, meaning giving the vendee, the part corresponding to the time he possessed the land in the last year, counted from the anniversary of the date of the sale. So, for accounting purposes or for valuing or valuation purposes, yan yung rule na i-apply natin. Kung at the time na binenta mo, walang fruits, and at the time na i-redeem mo na, meron ng fruits, you account for it kung kanina ba talaga yung fruits na yan. Okay, pero meron siyang rule dito na kayo na ang I will not touch that kasi hindi ako maano sa accounting. Okay, kayo na mag-ano dyan. Article 1618. The vendor who recovers the thing sold shall receive it free from all charges or mortgages constituted by the vendee. Meaning, kapag i-redeem mo yung or i-repurchase mo na yung property mo, kailangan wala siyang charges or mortgages na kinonstitute ni vendee. Let's say for example, nung binenta mo yan, hindi naman yan naka-mortgage sa bangko. Okay? Hindi mo naman yan ginamit na collateral. Of course, kapag ibibilhin mo na ulit yan, kailangan malinis yan. Hindi rin yan naka-mortgage sa bangko. Okay? The danger kasi niyan is, kapag naka-mortgage yan, okay, there is a possibility kapag hindi nakapagbayad yung nag-mortgage yan, na ma-foreclose yung property. Okay? Ma-foreclose yung property kapag ganyan. And your fear is, pwede makuha yung property, pwede mabenta on foreclosure sale. Okay? But, sabi dito, he shall respect the leases, which the vendee may have executed in good faith and in accordance with the custom of the place where the land is situated. Meaning, with regards to mortgages, charges, dapat wala. Pero with regards to leases, okay, or lease, dapat in good faith na nagawa. Let's say for example, property or building. Okay, kung meron mga nag-lease doon, okay, executed by the vendor in good faith, the vendor must respect it. Hindi niya pwedeng paalisin basta-basta yung mga lessee o yung mga nangungupahan doon. Okay, kasi in the first place, the vendor should be aware na meron nang nag-release doon kapag bibili niya na ulit yung property as part of due diligence. Okay? 1619, let's go to legal redemption. So we're done with conventional redemption. We talk about pacto de retro sale and equitable mortgage. Okay? Now we'll proceed with legal redemption. So what is legal redemption? Okay? Legal redemption is the right to be subrogated upon the same terms and conditions stipulated in the contract. Okay? In the place of one who acquires the thing by purchase or dasyon in payment or by any other transaction whereby ownership is transmitted by onerous title. Meaning, okay, from the word itself, legal redemption, the right to be subrogated in the place of one who acquires a thing. Take note, the acquisition here is by purchase or dasyon in payment or any transaction as long as the transaction is onerous or is transmitted by onerous title. So if the transaction is donation, wherein walang onerous title, okay, it does not apply. Legal redemption cannot apply. So, where does it apply? It applies to scenarios wherein co-owner sells to a third person or to a third party or a stranger. Okay? This right of redemption or legal redemption is similar to right of preemption. Ang difference lang niya kasi sa right of redemption, okay, a co-owner sells his share to a stranger or third party. In a right of preemption, okay, bago ibenta yan, you can exercise your right. Okay? So, the time period is what is considered. With regards to legal redemption, you exercise your right after the sale. When it comes to right of preemption, you exercise your right before the sale. Preempt. 1620, a co-owner, take note, a co-owner of a thing may exercise the right of redemption in case the shares of all the other co-owners or any of them are sold to a third person. Meaning, let's say, for example, ABC owns a property. Let's say, for example, they own it because of, by virtue of inheritance. Okay? ABC. Okay? A and B sold. So, onerous title. They sold their share to a third person. Let's say, for example, that third person is Z. Okay? Now, C can exercise his right to legal redemption, okay, against Z. Okay? Kumbaga, parang ibabalik niya yung property sa family tree nila. Okay? Kasi nga, the shares of all or any of them are being purchased by one. Okay? And the law favors that the property be returned to its original ownership. Okay? So, let's say, for example, magkakapatid si XYZ. Okay? Si X tsaka si Y, binenta nila, or si X lang, binenta niya yung property niya kay A. Ngayon, either Y or Z can redeem that property from A para bumalik yung property sa family tree nila. Okay? If the price of the alienation is grossly excessive, kung mahal yung pinagbenta dun sa share, the redemptioner shall pay only a reasonable one, of course. Diba? Even if the price stated is in the contract and it's really excessive, okay, then the redemptioner shall only pay a reasonable one. Even the courts can adjust the price. Diba? Should two or more co-owners desire to exercise the right of redemption, they may only do so in proportion to the share they may respectively have in the thing owned in common. Meaning, let's say, for example, just like my example a while ago, okay, AB sold, let's say, for example, kanina pala, X sold his share to A. Itong si Y and Z, they want to redeem that property. They can redeem it in proportion to their shares. Okay? 1621, the owners of adjoining lands. Ito na, adjoining lands. So, let's say for example, imagine this na lang kasi hindi natin magawa dito. Let's say for example, itong dots dito. Consider this as lands, di ba? Itong una owned by land A, itong pangalawa owned by ito owned by A, B, C, D. Okay? Ngayon, itong si B, okay, binenta niya yung property niya. Binenta niya yung property niya. Okay? The owners of adjoining lands, ang owners of adjoining lands, kung si B yung nagbenta ng property, ang owners of adjoining lands niya is si A, nakatabi ng lupa, and si C. Okay? The owners of adjoining lands shall also have the right of redemption when a piece of rural land. So take note, the subject here is a rural land. Okay? Meaning, these lands located in a not in a city or a town. Di ba? Yung mga nasa municipality na uh, hindi siya urban area. Okay? The area of which does not exceed 1 hectare. So, rural land area does not exceed 1 hectare and is alienated. Ibig sabihin, nabenta. So, ito si B, nabenta niya ito. Unless the grantee does not own any rural land. Okay? This right is not applicable to adjacent lands which are separated by brooks, drains, ravines, roads, and other apparent servitudes for the benefit of the estate. Meaning, if there is no brooks, drains, ravines, roads, and other apparent servitudes separating the land of A to the land of B, the land of B to the land of C, A or B can redeem the property sold by B. Why? Because the law prefers adjacent owners. Since ikaw na yung may-ari niyan, di ba, it must be favorable to you if you can utilize this land. Di ba? Or C can utilize this land. Di ba? Kesa naman na magpapasok ka ng ibang owner dyan na wala namang rural land sa area. Yung sabi niya dito, unless the grantee does not own any rural land in the area. Now, what if two or more adjoining owners exercise their right of redemption? Sino ang preferred? Okay? The owner of the adjoining land of the smaller area shall be preferred. Let's say, for example, if A owns 500 square meters of land and B owns 300 square meters of land, therefore, under the law, under Article 1621, B is preferred to exercise the right of legal redemption than A. Pero kung parehas sila ng area, let's say for example, parehas silang area ng 300 square meters, the one who first requested the redemption shall be preferred. Let's say for example, si A naman ang nauna, then si A ang preferred. Okay? Lance, reduce the volume. Whenever a piece of urban land which is so small and so situated that a major portion thereof cannot be used for any practical purpose within a reasonable time, meaning, take note, the subject here is an urban land, hindi na siya rural land. So, urban land meaning a land situated in towns and cities. Okay, but this land is so small, sobrang liit daw. Yung parang portion lang siya. And so situated that a major portion thereof cannot be used for any practical purpose within a reasonable time. Sobrang liit and so isolated or situated na wala kang makitang gamit ng property na yun. Let's say for example, a small corner lot na nahati. Wala kang makitang purpose na nun. And it is bought merely for speculation and it is about to be resolved. So parang binibenta-benta lang. Okay? The owner of any adjoining land has a right of preemption at a reasonable price. So, before siya ibenta, pwede mong i-exercise yung right, not a right of redemption, but a right of preemption. So, before siya mabenta, pwede mo siyang bilhin. At what price? At a reasonable price. Reasonable price is dependent on the circumstances surrounding the case. Okay? If the resale has been perfected, the owner of the adjoining land shall also have the right of redemption. So, ito dalawang right niya. Kapag urban land and so small and so situated, pwede niyang exercise yung right of preemption, meaning before the sale, and pwede niyang exercise yung right of redemption after the sale. Diba? Why? Because sobrang liit ng lupa na wala ka namang makitang use niya eh. Bakit hindi na lang yung katabi niya ang gumamit nun para magamit naman ng gusto? Diba? Yun yung Article 1622. When two or more owners of adjoining lands wish to exercise right of preemption or redemption, the owner whose intended use of the land in question appears best justified shall be preferred. So, in case na dalawa yung adjoining land, kung sino daw yung may makapag-justify ng best use ng land, then therefore siya yung may-ari. And that could be best decided. If it cannot be decided amicably, it can be decided by the court. Okay? In the last article, I think last na to, 1623, the right of legal preemption or redemption shall not be exercised except within 30 days from the notice in writing by the prospective vendor. So meaning, if you want to exercise your right of redemption or right of preemption, you must give a notice in writing, hindi oral, within 30 days from the sale, or by the vendor as the case may be. The deed of sale shall not be recorded in the registry of property unless accompanied by an affidavit of the vendor that he has given written notice thereof to all possible redemptioners. So this is what you can do to exercise your right of redemption or right of preemption. How? You first give notice in writing. Okay, you give a notice in writing that you are exercising your right of redemption or preemption. After that, if nabenta mo na, you are to execute an affidavit that you have given a written notice to all possible redemptioners. Sino yung all possible redemptioners? Lahat ng adjacent owners, lahat ng katabing lupa. Nabigyan mo ng notice. Why? For them to contest your claim. Kung gusto din nilang gamitin yung lupa, pwede din nila kasing gamitin kasi adjacent owners din sila. Okay? The right of redemption of co-owners excludes that of adjoining co-owners. Take note, the right of redemption of co-owners excludes that of adjoining co-owners. So, balik tayo dun sa basic na kung itong lupa, let's say for example, this one, this lot right here in the middle is owned by A, B, and C. Co-owners sila. This is owned by D. This is owned by E. Okay? The right of redemption of co-owners excludes that of adjoining owners. Ibig sabihin, let's say for example, A sold this share in this one. So gustong i-exercise ni D tsaka ni E yung right of redemption nila. Hindi pwede. Why? Because right of redemption of B and C, yung other co-owners ni A, excludes the right of adjoining owners. So kumbaga, yung co-owners, they will exclude the adjoining owners. That's the limitation. Okay, and that is Article 1623, and that finishes our topic. Okay? Thank you.